Now have an opportunity for silent prayer or meditation. Please be seated. Honorable members, I've been informed that the whipper has agreed that there won't be any. What is the point of order, Honorable?
Am I on the floor, Chair?
Recognizing you.
Chairperson, you know, you consistently come late in the house. So you must tell us now what must happen. Because you as the chairperson, coming late into the house sitting, and then it leaves us with no choice but then to escalate this matter. But first I will give you the opportunity to tell us what must happen. Thank you, Chair.
No, honorable members, Honorable Koni, that is not a point of order in the first place. And secondly, your last part of your statement that you have concluded to escalate the matter. Can I give you that opportunity to escalate it? Thank you very much. Honorable members have been informed by the whippery that they have agreed that there won't be any motions. At the same time, I would therefore call on the Chief Whip on a statement for the amendment of the order paper. Can I recognize you? On what point is that? Can I respond to that before you do? The member is in the house. Can we proceed with the business of the day? Okay. Honorable Chief Whip.
Thank you very much, Deputy Chairperson. I move that, Deputy Chair, that on the orders of the day number 11, I move that the matter be deferred for further business. Item number 11, thanks.
Thank you very much. Are we agreed? Agreed. The Secretary will read the first order of the day.
Voting on second report of Joint Committee on Ethics and Members' Interests, late disclosures for 2016.
Honorable Singh.
Thank you, Chair. The report on the Joint Committee of Ethics and Members' Interests on the complaint against Honourable Figlin, MP, dated 29th of November 2017. On the background, on July 18th,
yes, can I recognize that?
Thank you, Chair. Chair, I'm rising on a point of order. Maybe you don't ask us why are we sitting where we are seated. And no, this matter has been debated in the House. We decided that we do this to alert you as a chair that this House has never been consistent in the rules that govern it. Last time, there were an issue about myself. I was seated where I'm supposed to be sitting. In my province, I was told to move. Today, I'm seated in a province where I don't belong. No one is saying anything. My colleague here is seated there. No one is saying anything. My colleague is here sitting here. No one is saying anything. Now I want to caution this House about its inconsistency in terms of taking or rules or ruling in terms of the decorum of this House. I thank you, Chair. Thank you very much.
I don't need to make a ruling on that matter because I'd already made a ruling on it. So can we continue with the debate, Honourable Member?
Thank you, Chair. The report of the Joint Committee of Ethics and Members' Interest.
Can you just take a seat, please? Honorable Singh, can I just address this matter quickly? Honorable Singh, let me just ascertain. Which report are you reading?
I'm reading the report, a Joint Committee of Ethics and Members' Interest complaint against Honourable Figlin.
Okay, fine. A matter has just been brought to my attention that in terms of the order paper, the second reading of the Joint Committee on Ethics and Members' Interest report was dealt with and presented in the House in the last sitting. But voting did not take place because of the matter had to be referred back to the committee for the Ethics Committee then to finalize it insofar as sanctions and other things are concerned. So what we need to do before even we get to the second item on the order paper, we need to conclude with the voting on that report that was report presented to the House in the last sitting. So we first need to dispose of that one, and then now we get to the second item on the order paper. With that understanding, shall I then call on the Secretary to read the first order? Or you've read it already? Okay. Now, honorable members, on the basis of that explanation, I will therefore put the question, and the question is that the report be agreed to. And I shall first ascertain whether if all delegation heads are present in the House. Are they?
Clarity on what report are we voting on now?
The first order on the order paper. Let me explain it again, just so that all of us are on the same page. The report was read and presented in the House in the last sitting. But the report was then not adopted on the basis that it had to be referred back to the committee, so that the committee must then finalize those gaps or close those gaps that were there. And one of them was the sanctions that the committee had to present to this House. Now, the House agreed that the report be referred back to the committee, and that's exactly what happened. Now, what we need to do, after all those processes have been concluded by the committee, is now to vote and not to receive the same report that we received the last time. That's where we are now, to vote on the report that we received in the last sitting. Honorable Kaula.
Thanks, Honorable Chairperson. So what the Chair is saying, after it has been referred to the committee, there are no changes in what they are going to report today from what they had read to us last time.
Whatever it may be, what the committee did, we are just proceeding as agreed to, that for now, we will be voting on the report. Point of order?
Now I don't know why are we debating. Which rule are we using today to debate whether the report must be read to us or not read to us? What does the order paper says? Are we not prepared for today's sitting? If we are not prepared for today's sitting, why are we debating that thing? I'm just checking, Chair, because we cannot just discuss this matter like this. It's either it's voting or no voting. Or the guy comes there and read that report and then we vote. That's the only thing that we need to. We cannot just sit here and then debate whether the report was read to us or not read. He must know, as the chairperson of that committee, whether he's presenting to us something that he presented to us before. Please, Chair, let us not waste time.
Thank you very much, Honorable Mokwele. I don't think there's any waste of time because you agree with us. There's nothing different that you are raising, and therefore that order is not carried. Honorable members, shall we proceed with the voting on the order? Eastern Cape.
Eastern Cape supported, Chair.
Honorable Mokwele, the word that you just used, can you please withdraw? Thank you very much. Eastern Cape. You've already voted, okay. Free State.
Free State support, Chair.
Gauteng.
Gauteng supports, but.
KwaZulu Natal.
KwaZulu support, sir.
Limpopo.
Limpopo Redume.
Mpumalanga.
Mpumalanga, Chris.
Northern Cape.
Northern Cape support, Chair.
Northwest.
We agree, Chair.
Western Cape.
Western Cape support.
All 9 provinces voted in favor. I therefore declare the report is agreed to in terms of Section 65 of the Constitution. The Secretary will read the second order of the day.
Consideration of report of Joint Committee on Ethics and Members' Interests, complaint against Honorable Fichlan, MP, dated 29 November 2017.
Honorable Singh.
Chairperson, I want to raise.
Honorable Singh, I'm not, Honorable Mokwele. Honorable Mokwele. Honorable Mokwele. Honorable Mokwele, I have not recognized you. May I order, honorable members. Order, honorable members. Honorable members, order. I have called on Honorable Singh. And I'm recognizing Honorable Labuskaghni on a point of order that she's raising. Honorable Labuskaghni.
Thank you, Chairperson. I raise a point of order on the report that is now for considering in the NCOP. And the reason why I raise a point of order is if you read the Code of Ethical Conduct and Disclosure of Members' Interests, Chapter 10.7.8, it reads as follows. The committee to report to appropriate house. The committee must report its findings and its recommendations as to penalties, if any, to the appropriate house. If the committee recommends a penalty, the house must either accept or reject the recommendation or refer the matter back to the committee for further consideration. If the house has accepted the committee's recommendation, the findings become final and the speaker or the chairperson of the council must act on such decision promptly. I just want to draw to your attention that Honourable Ficklin is not a member of the NCOP, but a member of the NA. The member is not in the House today, and therefore, I don't think this is correct to table the report in the NCOP. This is the first objection. The second one is, Honourable Ficklin's report was part of a big, thick pack of reports. If that honourable member's report has been tabled in the NCOP, where are the other reports? Thank you.
No, honourable members, ordinarily, the issue raised by Honourable Labuskaghni would have been much more appropriate if it came through as a declaration after the report. Because two issues that have served before this House. One is that the Ethics Committee is a joint committee. It's a joint committee of Parliament made up of these two houses, that is the National Assembly and the National Council of Provinces. So whatever that serves before that committee, both houses must be appraised of what is happening in that committee. And that brings us back to what we as a House has received even before. We dealt with an Ethics Committee report that spoke about the report as it spoke to the issues around the Speaker of the National Assembly. And this House received that report. There was no objection to that, who is not a member of this House. And the House received that report. So this report that is being presented to us is a report that comes, or that has been generated by a joint sitting or a joint committee of Parliament made up of the NA and the National Council of Provinces. And in this instance, the National Council of Provinces is affording itself an opportunity to be brought up to speed with the report that came out of that committee. So that is exactly what we are doing here, honourable members. I think I've responded to that. So can we continue with the business of the day? Honourable Singh, can you continue?
Thank you, Chairperson, for the explanation. This is a report on Joint Committee of Ethics and Members' Interest on the complaint against Honourable Ficklin, MP, dated 29th November 2017. The background: on the 18th of June 2015, the Office of the Registrar received a complaint submitted by the Chief Whip of the Majority Party to the Joint Committee of Ethics and Members' Interest. The complaint referred to an incident regarding an allegation of sexual harassment of a member of the public by Honourable Ficklin, which took place during the protest march in Cape Town ahead of the State of the Nation address in 2015. Considering the code in respect of the allegations against Honourable Ficklin, in terms of paragraph 10.3.2 of the code, the registrar collated the necessary information and made the informed recommendation to the Joint Committee. Media reports reflect that the Democratic Alliance found Honourable Ficklin guilty of sexual harassment and imposed sanctions on him in respect of the matter. Notwithstanding same, the code addresses the code of conduct for members in the capacity as a member of Parliament rather than a representative of a particular political party. This is according to no reason why a member who has undergone a disciplinary process within his or her party should be exempted from such a process in terms of the code. The allegation against Honourable Ficklin can be considered on the following basis. 2.4.1, Chapter 2 of the Constitution, the Supreme Law of South Africa, provides that all persons have rights not to be treated in a degrading way, the right to bodily integrity and the right to human dignity. Sexual harassment constitutes infringement of these rights, and a failure on the part of a member to uphold these rights of the alleged victim, the member has accordingly not upheld the law. The member's conduct, although a non-parliamentary event, in a non-parliamentary is in breach of the code, would demand that members act at all times in accordance with the public trust placed in them. A member has committed an act of sexual harassment, throws into question the trust. 2.5.1 of the act of sexual harassment committed by the member of parliament, especially one that has been made in public, has the effect of eroding public confidence and trust in the integrity of parliament. The recommendations from the register recommended that as the alleged victim was found and had agreed to appear before the committee hearing, that the hearing be held to consider the facts. At the meeting on the 28th October 2015, the committee agreed that a subcommittee be established to consider the facts. The subcommittee duly constituted the nominations from different political parties. Honorable Figlin's attorney submitted correspondence questioning the aspects of procedure and the committee decision to hold a hearing. Further correspondence sent to Honorable Figlin explaining the committee's procedure. The member was charged with sexual harassment and contravention of the following codes of conduct. The register stated that in terms of paragraph 2.3 of the Code of Ethical Conduct for members have a duty to create public interest and confidence in the public representative and to protect the integrity of Parliament. The hearing on the 1st of March 2016 concluded the facts and that the member was found guilty. The register recommended that the member be fined 30 days salary and a suspension of privileges for 15 days. Thank you.
Thank you very much. That concludes the debate. I shall now put a question, and the question is that the report be agreed to. But in accordance with Rule 75, I shall first ascertain whether if there's any province that wishes to make a declaration of vote. Western Cape.
Thank you, Chairperson. On behalf of the Western Cape, I want to make a declaration on the following points on the procedures and processes of the Ethics Committee. I raised on the point that the Code of Ethical Conduct and Disclosure of Members' Interests exactly stated that the reports have to be dealt with in the appropriate houses. The chairperson ruled that it is a joint committee. This code doesn't make reference to the joint committee because a member of the NA is not a member of the NCOP and a member of the NCOP is not a member of the NA. The fact that it slipped through is not because, it cannot be seen as that it is a justification because that is the role of the chairpersons of that committee and the chief whip. The fact that other NA members wrongfully were discussed in this house is not a justification. If I have to raise in this house on every single thing that's wrong, I will have to stand permanently on a point of order. So therefore, Chairperson, we will not support this report. Thank you.
Thank you very much. Is there any other province? In the absence of any, we shall then proceed with the voting in an Gauteng.
Chairperson, on behalf of Gauteng, we need to make it clear, firstly, that I have been appointed as a member of the Ethics Committee in this Parliament. Of the big challenges that we have in this committee is to be ethical. Being ethical, Chairperson, is therefore not something that applies to one house and not to the other. It applies to both.
Honorable member, this is a declaration.
I'm making my declaration.
Just hold it, honorable member. On what grounds will we be calling on a point of order on a declaration?
No, I want to check whether the member is on a mandated declaration from the province. Because by the look of things, Gauteng doesn't have a mandate. We have a member in Gauteng who told us that they don't have a mandate on this matter. So I want to check whether it's a mandated declaration that he's giving to us.
No, honorable members, I would not sustain that point of order because we just received a point of order, a declaration from the Western Cape, and there's no one who rose to check whether if there's a mandated. So therefore, on the basis of that, can you continue with the declaration?
Chairperson, we want to say...
Honorable Mokwele, can you be in order, please? Honorable Mokwele, can you be in order, please? Gauteng, I asked for a province, and Gauteng is making a declaration. Can you allow the province to make a declaration? Can you continue?
Chair, we want to say that it is, for me, in this declaration, very important that we not be diverted from the matter that is before us. We were, as members of this ethics committee, extremely perturbed by what has happened, and therefore consider the matter that is before us with that sensitivity, also in terms of the patriarchy that is such a big challenge for us in this country. And that is what we wanted to say. Thank you, Chair.
Honorable Mokwele.
Chair, ka tswetswe, re o fetsang go bua, o na sa bui jaaka moleloko wa ko Gauteng province, mme o na bua jaaka moleloko wa committee. So he's not speaking on behalf of the province, he's speaking on behalf of committee of ethics. So that declaration cannot be noted. It's an individual declaration, like I said before. It's not the declaration from the province.
Honorable members, order, honorable members. Honorable Mokwele, once more, order. Honorable Louis, can you please be in order? Honorable Louis. Honorable Louis. Honorable Louis. Honorable Louis. Can you please be in order? Honorable members, I asked for a declaration. And there was a declaration by the Western Cape. And I asked for a declaration from any other province. And a Gauteng permanent delegate rose on behalf of the province. And therefore, that is what we are taking now. Can we then proceed with the voting on the question? Okay. Honorable Gaila.
Chairperson, Honorable Lowe is not respecting you. Ask him to leave the house, please. Please.
No, I'm not going to do that. Is that a declaration?
Northwest declaration from Bokoni Bupirima ke gore declaration e beilweng ke Gauteng.
Can you take a seat, honorable member?
Chair, the member rising and speaking on behalf of Northwest is not properly and adequately mandated to speak on the Northwest. And as the leader of the delegation, I would request that we don't apportionate that opportunity.
Honorable members, can we proceed with the voting on the question? Eastern Cape?
Eastern Cape support, Chair.
Free State?
Free State support, Chair.
Gauteng?
Gauteng fully supports, Chair.
KwaZulu-Natal?
KwaZulu-Natal support, Chair.
Limpopo?
Limpopo ra dumela.
Mpumalanga?
Mpumalanga agrees to the report, Chair.
Northern Cape?
Northern Cape support, Chair.
Northwest?
We agree, Chair.
Western Cape?
Agree.
Oppose.
Western Cape?
Oppose.
8 provinces voted in favor and 1 province voted against. Therefore, the majority of provinces voted in favor. I shall therefore declare the report as agreed to in terms of Section 65 of the Constitution. The Secretary will read the third order.
Consideration of report of Select Committee on Petitions and Executive Undertakings, hearing of the Love Neisner petition held on 10 February 2016, 16 March 2016, and 24 March 2018 at Parliament.
Honorable Klimbi.
That's my chance. Thank you very much, Chairperson. Thank you very much. Chairperson, the Love Neisner petition was submitted to the National Council of Provinces by Mr. Hampton, a community activist and from Neisner in the Western Cape. The petition is supplemented by Ms. S. Campbell, who is also a community activist from Neisner in the Western Cape. The petition was referred to the Select Committee on Petitions and Executive Undertaking by the Office of the Chairperson of the Council on the 28th of April 2015. Chairperson, the petition levels complaints against Neisner local municipality in relation to the following: the alleged criminal funding of Neisner tourism with taxpayers' money, the alleged illegal awarding of the Integrated Strategic Development Framework tender of the municipality to Neisner creative heads, a consortium which had not scored the highest points during the tender process and is headed by a complicated local property developer. The alleged illegal appointment of Mr. Grant Astin as municipality manager by the municipality and the irregularities committed following his appointment as municipality manager, as well as in his previous appointment as chief financial officer of the municipality. The alleged unconstitutional blocking of his communication at both a local and provincial level as a result of allegation contained in the petition. And in the petition, Mr. Hampton seeks the intervention of the NCOP in investigating the complaints he levels against the municipality. The committee held a total of 3 hearings on the petition. The first hearing on the petition was held on the 10th of February 2016. The second hearing was held on the 16th of March 2016, and the final hearing on the petition was held on the 24th of May 2017. Before the committee held the final hearing on the petition, it tabled a primary report on the petition in his house on the 19th of May 2016. Herein it requested Western Cape Provincial Treasurer, together with the Western Cape Department of Local Government and the Office of the Public Protector, to finish their findings on some of the issues raised in the petition. Chairperson, the committee made this request in order to avoid a situation wherein it finds itself running parallel processes with these two bodies. The committee is happy to report that after the tabling of the preliminary report on the petition, both the Western Cape Department of Local Government and the Office of the Public Protector subsequently shared their findings on the petition with the committee. It is also important to point out that after the tabling of the preliminary report, the committee took a resolution to hold a third and final hearing on the petition after the petitioner indicated that he had new information or evidence to share with the committee on the petition. That having been said, after holding all 3 hearings on the petition, the committee makes the following observation and key findings. Aspects of the new information or evidence that Mr. Hampton submitted to the committee during the third hearing on the petition built on the submission he had already made to the committee during the first hearing on the petition. The municipality later suspended and charged Mr. Aston, the former municipality manager of the municipality, at the instance of Ms. Campbell's complaints against his appointment as municipal manager. Numerous charges were drawn up against Mr. Aston by the municipality, and these charges included, amongst others, the failure to ensure the implementation of recommendation from the Auditor General in relation to awarding of tender or contracts to local suppliers and breaching supply chain management and procurement and procedures in allowing the continuous use of the local premium preferences policy. Mr. Aston resigned from his position as a municipal manager before his disciplinary hearing could be concluded. Chairperson, it is against these key findings and observations that the committee also makes the following recommendations. The National Office of the Public Protector investigate all the issues raised in the petition. That the National Office of the Public Protector further investigate the reluctance on the part of the provincial office to investigate the complaints raised in the petition. That the National Office of Public Protector report to the committee on the progress it has made investigating the issues raised in the petition within 60 days of the tabling of this report in the House. Chairperson, in conclusion, the Select Committee on Petition and Executive Undertakings recommends as follows: that the House adopt the final report on the Love Neisner petition as tabled by the committee today. So moved. Thank you, Chairperson. Thank you.
Thank you very much. That concludes the debate. Honorable member, on what point are you rising?
Thank you very much, Honorable Chairperson. Honorable Chairperson, the issue that Honorable Klimi has raised on this report is very problematic, even before we go to a debate. The public protector, if you look at his recommendations that the public protector must investigate this matter, I want to assist him. The public protector has no jurisdiction because this matter happened more than 2 years ago. That was 2015. Now this is 2018. So that recommendation is not going to work. It's outside the jurisdiction. Secondly and lastly, let me assist also the Petitions Committee. Can I be protected, Chair? I'm on the floor.
Honorable member. No, honorable member. Honorable member.
Can I be protected, Chair? I'm still speaking. I can only be ruled out by you, not by Honorable Dlamini. She must not be excited.
I don't know why our members doing this. I don't know why our members doing this. You're not supposed to do that. You're not supposed to do that. Please, allow the presiding officer to determine whether if the member is already making a declaration or a member is debating or a member is doing whatever that is doing. Another point, as you are raising now, honorable member, I think you are now at a point of debate. It is no longer a point of order. So therefore, can we proceed with the business of the day, and then section 71, if it permits you, it will allow you to make a declaration.
I have no problem, Chair. I have no problem. I've made my point.
Thank you very much.
I've made my point. Thank you.
Thank you very much. Are all delegates? Can you take your seat, honorable member? I tried to caution members even yesterday. I tried to caution members, but members keep on doing this thing. And I don't know why are we doing this. Please, can we just treat each other? Can we look at each other and treat at each other with the greatest of respect? Honorable Dlamini, I'm addressing the House. Can we please address each other with the greatest of respect as honorable members? You might differ with another member, yes. This is a multi-party democracy. This is a policy house. We differ, whether ideologically, theoretically, and otherwise. We will have our own differences, but let's respect one another. on the basis of our differences. Thank you very much. Then, are all the heads of delegations in the House? Honorable Lond.
It's, no,
What
it's
point are you
Honorable
raising?
Smith, Deputy Chair. I want to hear if it's parliamentary for the Honorable Kathy Dlamini to play Candy Crush on her computer while you are busy in the House.
It may not, it will not be. And if Honorable Kathy, it is true that is what you are doing, please stop doing that. Can we proceed with the voting? Can we proceed? Can we proceed with the voting? In an alphabetical order, Eastern Cape,
Eastern Cape support, Chair.
Free State,
Free State ya amohela Chair.
Gauteng,
Gauteng supports the recommendation.
KwaZulu Natal,
Natal support, Chair.
Limpopo,
Limpopo supports.
Mpumalanga,
Mpumalanga agrees.
Northern Cape,
Northern Cape supports, Chair.
Northwest,
We agree, Chair.
Western Cape,
Don't support, Chairperson.
Western Cape,
Not support.
or you don't support?
Thank you.
8 provinces voted in favor, against 1 province who voted against. Therefore, the majority of provinces voted in favor. I shall therefore declare the vote as agreed to in terms of section 65 of the Constitution. I wonder if a member can be asked in terms of what section was that report voted on, whether if members would remember. Especially those members who do not listen and continue to engage with each other, you know, in a very aggressive way. The secretary will read. Okay. Okay. I refer, Honorable Koni. Honorable Koni. You know, I just want to make things simple because yesterday I didn't necessarily read it out. I presented it to the House. But let me just remind members. No. Can you be in order, please, and be respectful? You can't tell me that you don't have to. No, it's not about you. It's not about you. It's about the House. Honorable Mokweli. Honorable Mokweli. Honorable members, I want to take the opportunity to address ourselves to Chapter 1, Part 1, where it says that members have a right of freedom of speech in the Council and its committees and subcommittees, subject to these rules. Members are not liable to any civil or criminal proceedings, arrest, imprisonment, or damages for anything they have said, produced before a subcommittee of the Council or any of its committees or subcommittees. Anything revealed as a result of anything said, produced before or submitted to the Council or any such committee or subcommittee. Therefore, members, 32, it says that during a debate in the Council, no member may converse aloud. It doesn't say members should not converse, but converse aloud to a point where even a member becomes disruptive. You can converse, there's nothing wrong in conversing. Now, I'm reading this out, risking a situation of turning this House into a rules workshop, and I don't want to do that. I just raised it to remind members. What is the point of order?
Chairperson, the point of order that the rule that you've just raised, does it only apply to EFF members and not ANC members? Clarify me on that, thank you.
No,
Because
I read it to the
yesterday
House.
it was only applied to the honorable member of the EFF only.
I requested to address the House on the matter. So I was not addressing any political party or any individual. I addressed the House, meaning therefore all members of this House. All right. Honorable members, we have voted on the report. The Secretary will read the fourth order of the day.
Consideration of report of Select Committee on Security and Justice, withholding of remuneration of Magistrate Ms. J.F. van Schalkwyk, Chief Magistrate Kempton Park, tabled in terms of section 13(4)(a) sub B of the Magistrates Act 1993, Act number 90 of 1993.
Honorable Mtimonye.
Thank you, Deputy Chair. Deputy Chair, the Select Committee on Security and Justice, having considered the Magistrates Commission report dated 29 November 2017, as tabled by the Minister of Justice and Correctional Services on their determination to withhold the remuneration of Magistrate Mrs. J.F. van Schalkwyk, Chief Magistrate at Kempton Park, tabled by the Minister for Justice and Correctional Services in terms of Section 31, subsection 4 of the Magistrates Act of 1993, Act number 90. The committee therefore reports as follows. Just by way of background, Honorable Deputy Chair, the Magistrates Commission at its meeting held on 11 May 2013 agreed to provisionally suspend Mrs. van Schalkwyk pending an investigation into her fitness to hold office as contemplated in terms of Section 13, subsection 3A of the Magistrates Act, Act number 90 of 1993. Parliament on the 12th of November 2013 confirmed Mrs. van Schalkwyk provisional suspension from office. After a preliminary investigation, the Magistrates Commission charged Mrs. van Schalkwyk with 18 counts of misconduct. Ms. van Schalkwyk, then attorney, acknowledged receipt of the charge sheet on the 1st of August 2013 on her behalf. The Magistrates Commission holds the view that Mrs. van Schalkwyk is deliberately delaying the disciplinary process against her and that a determination by the Commission to withhold her remuneration is justified. Due process has been followed and the High Court dismissed her application. The judgments in this regard are clear. Her representations not withholding her remuneration therefore have no substance. Having regard to the fact that it is evident that Ms. van Schalkwyk deliberately delayed the continuation of the disciplinary process against her and the serious nature of her misconduct charges preferred against her, the Commission at its meeting held on the 24th of November 2017 determined to withhold Mrs. van Schalkwyk remuneration in terms of Section 13, subsection 4 of the Magistrates Act, pending the conclusion of the disciplinary inquiry against her with immediate effect. The Select Committee on Security and Justice, having considered the Minister's report on the Magistrates Commission determination to withhold the remuneration of the magistrate, Mrs. J.F. van Schalkwyk, Chief Magistrate at Kempton Park, tabled by the Minister of Justice and Correctional Services in terms of Section 13, subsection 4 of the Magistrates Act, the committee recommends to confirm the determination of the Magistrates Commission. I therefore table the report for consideration, Chair.
Thank you very much. That concludes the debate, and I shall now put the question, and the question is that the report be agreed to. In accordance with Rule 71, I shall first allow provinces an opportunity to make a declaration of vote if they so wish. Is there any province? In the absence of any, we shall proceed with the voting in an alphabetical order. Eastern Cape?
Eastern Cape, support, Chair.
Free State?
Free State, support, Chair.
Gauteng?
Gauteng agrees.
KwaZulu-Natal?
KwaZulu-Natal, yafo.
Limpopo?
Limpopo, ready,
Mpumalanga?
Mpumalanga yavuma, Chair.
Northern Cape?
Northern Cape, yavuma, Chair.
Northwest?
We agree, Chair.
Western Cape?
Western Cape agrees.
All 9 provinces voted in favor. I therefore declare the report as agreed to in terms of Section 65 of the Constitution. The Secretary will read the 5th order of the day.
Consideration of report of Select Committee on Security and Justice, suspension from office of Magistrate Mr. IWOM Morake, Magistrate at Lichtenburg, tabled in terms of Section 13, sub 4, sub A, sub 1 of the Magistrates Act 1993.
Honorable G.G. Oliphant.
Thank you, Chair. The Select Committee on Security and Justice, having considered the Magistrate Commission report dated 8 February 2018 as tabled by the Minister of Justice and Correctional Service, on the suspension and removal from office of Mr. Aho Morake, Magistrate of Lichtenburg, on the ground of misconduct in terms of Section 13(4)(a)(1) of the Magistrate Act 1993, Act 90 of 1993. Herein after the Act reports as follows. Mr. Morake is the Magistrate and Judicial Head of Lichtenburg. The Commission charged Mr. Morake with 6 counts of misconduct which are contained in a charge sheet which was served on Mr. Morake on 29 December 2010. One of the counts related to the fact that the Regional Court Lichtenburg on 18 October 2010 convicted him of 2 counts of theft. On 13 July 2007, Mr. Morake appeared in the Lichtenburg Regional Court on 3 charges of theft. On 21 July 2011, the court sentenced him to 4 years imprisonment on each count in terms of Section 276I of the Criminal Procedures Act. The presiding officer delivered judgment on 23 June 2017 and found Mr. Morake guilty of 5 counts of misconduct. The presiding officer imposed a sanction on 16 November 2017 in terms of Regulation 2617B of the Regulation for Judicial Officers in the Lower Courts. 1994, the regulation recommended to the Commission that Mr. Morake be removed from office as contemplated in the Section 13 of the Act. Having duly considered all the required documentation presented to it, the Commission Executive Committee on 30 January 2018 resolved to recommend that Mr. Morake be removed from office in terms of Section 13(4)(a) of the Act. Legal position. In terms of the Section 13(4)(a) of the Magistrate Act 90 of 1993, the Minister, on the advice of the Magistrate Commission, must suspend that magistrate from office, or if the magistrate is at the stage provisionally suspended in terms of subsection 1A, confirm the suspension. A report in which the suspension in terms of paragraph A of the magistrate and the reason therefore are made known. Must be tabled in Parliament by the Minister within 14 days of such suspension. If Parliament is then in session, or if Parliament is not then in session within 14 days after the commencement of its next ensuing session in terms of Section 13(4)(b) of the Act, Parliament must then, as soon as is reasonably possible, pass resolution as to whether or not the restoration of his/her office of the magistrate so suspended is recommended in terms of Section 13(4)(c) of the Act. After a resolution has been passed by Parliament as contemplated in paragraph 4.3, the Minister shall restore the magistrate concerned to his or remove him from office as the case may be. Committee recommendation to the NCOP for approval. The Select Committee on Security and Justice, having considered the Magistrate Commission report date 8 February 2018 as tabled by the Minister of Justice and Correctional Service on the suspension from the office of Mr. Aho Morake, Magistrate of Lichtenburg on the ground of misconduct in terms of the section 13(4)(a)(1) of the Magistrate Act 1993. Recommend that the National Council of Province does not restore Mr. Morake to the office of the magistrate. Thank you, Chair.
Thank you very much. That concludes the debate. I shall now put a question, and the question is that the report be agreed to. In accordance with Rule 75, I shall first afford any province an opportunity to make a declaration of vote if they so wish. Is there any province that wishes to make a declaration of vote? In the absence of any, we shall then proceed with the voting in an alphabetical order. Eastern Cape?
Eastern Cape support the report, Chair.
Free State?
Free State support, Chair.
Gauteng?
Gauteng supports.
KwaZulu-Natal?
KwaZulu-Natal support, Chair.
Limpopo?
Limpopo yavumelana.
Mpumalanga?
Mpumalanga is agreeable to the report, Chair.
Northern Cape?
Northern Cape doesn't support?
The Northern Cape supports the report. Thanks, Chair.
Northwest?
We agreed, Chair.
Western Cape?
Western Cape support, Chair.
Yes, can I hear the point of order?
I just want to check with you, Chair. You know, this is the 5th question I'm posing to you today about the processes and procedures of the House. Is it permissible for a province to be given 2 chances of voting?
Honorable Member Mukwele, I know why you're asking this question. Insofar as the records of this parliament is concerned, the person mandated to be the leader of the delegation on behalf of the Premier of the Northern Cape is Honorable Stock. That is what the records of this parliament knows. If he is unavailable, let me explain that process. Can you take your seat? No, oh, okay. Okay, in the absence, honorable members, that is in terms of the Constitution, not even the rules. In the absence of the delegated member of the permanent delegates by a legislature, that member can then delegate that responsibility to any member of the permanent delegates to the National Council of Provinces. Yes.
On that matter.
Is that a point of order?
Yes. Yeah.
Members
yes.
Are,
yes. According to the observation today, Mayor Honorable Oliphant, has been in the House and he has been voting on behalf of Northern Cape in the presence of the leader of delegation. You have never highlighted or alluded to us as the House that Honorable Stock in his presence is absent. But it's fine, I'm just sharing with you. When we come back, don't say we didn't warn you. Thank you.
Well, that's a side comment. What makes it even worse is that Honorable Stock is in the House. What he has arranged with his delegation, I don't know. So, Honorable Member,
may I address you again? You see, when you take decisions out of emotions, you will forever commit mistakes. You don't know what was the arrangement of Northern Cape, right? But Honorable Koni has voted on behalf of the Northern Cape, and then you turned over that voting right of Honorable Koni, and you don't know what was the arrangement amongst them as delegates. So again, Chair, you are wrong. Thank you. No, it's fine. I'm just doing that.
for the purpose of your ease, because you know, I don't want for us to get out of here having different and wrong understandings. Honorable Stock is in the House. I'm calling on the Northern Cape. Honorable Kony votes. And Honorable Stock is raising his hand. He's on his feet. So I'm recognizing Honorable Stock. I'm looking at him. Whereas Honorable Kony didn't see Honorable Stock. So therefore, I recognized Honorable Stock. Therefore, honorable members, no, I spoke for myself. I spoke for myself. No. Okay, fine. I recognized Honorable Stock. Honorable Kony, Honorable Oliphant. Honorable Oliphant, no. And that's another thing also that we need to address. I mean, I tried earlier on. Can you take your seats, honorable members? I tried to address this thing of respect amongst ourselves earlier on. Honorable Oliphant, you are speaking to another member and you're pointing that member with a finger. It's not good. No. If they do that, it is for me to caution them not to do it. But don't, because of how next. Don't worse. So please, let's not do that. Honorable members, 9 provinces.
Chair, I'm going back to that issue of Northern Cape on processes with due respect. I'm not disputing your ruling, but I think you saw Honorable Stock standing up from his seat, going and give Honorable Kony an instruction on voting. You saw him, whilst Mama Oliphant was busy there, Honorable Stock stood up, went to Honorable Kony, he even saluted to you. He went to Honorable Kony to say, on my absence while I'm present in the House, you must vote on behalf of Northern Cape. It's just for you to note that. Thank you very much.
Honorable members, I've made a ruling on this matter. Can we just proceed? I'm not going to entertain this issue any further. All 9 provinces voted in favor. I therefore declare the report as agreed to in terms of Section 65 of the Constitution. The Secretary will read the 5th order, the 6th order, yes.
Consideration of report of Select Committee on Security and Justice, withholding of remuneration of Magistrate MSR Malahlela and additional magistrate at Delmas, tabled in terms of Section 13, Sub 4A, Sub B of the Magistrates Act, 1993.
Thank you once more, Deputy Chair. Deputy Chair, the Select Committee on Security and Justice, having considered the Magistrates Commission report dated 29 November 2017, as tabled by the Minister of Justice and Correctional Services, on their determination to withhold the remuneration of Magistrate Mrs. R.M. Malahlela, an aspirant additional magistrate at Dalmas, tabled by the Minister of Justice and Correctional Services in terms of Section 13, Sub A, Sub B of the Magistrates Act, 1993. The committee reports as follows. Just a little background, Honorable Deputy Chair. Mrs. Malahlela is an aspirant additional magistrate at the Dalmas District Court. She is 54 years of age and has been appointed to a lower court bench on 1 November 2004. She is still on probation. The Minister, on the advice of the Commission, provisionally suspended Mrs. Malahlela from office with effect from 17 July 2014, which provisional suspension was confirmed by both Houses of Parliament on the 6th and the 18th of November 2014, respectively. Her permanent appointment could not be finalized due to poor performance, irregularities in her work, absenteeism from office, refusal to execute lawful orders, major delays in handing down judgments, failure to finalize matters, and poor utilization of court time. Her evaluation reports indicate that she is not a fit and a proper person for appointment as a magistrate. Mrs. Malahlela was for a considerable period absent from work, and in default of explaining her absence, she could not satisfy the commission that she is a fit and a proper person to be appointed as a magistrate. Medical reports indicated that she suffered from major depressive disorder and panic disorder. The condition, however, does not render her unfit to do work, but she has to continue with monthly psychotherapy and medication. A report dated 18 October 2011 recommended that she does not have the capacity to carry out her duties of office in an efficient manner due to continued ill health, and that she should furnish reasons in terms of Regulation 29 of the regulations. This is now the regulations regulating the magistrate or the judicial officers of lower courts, Chair. The Ethics Committee on the 6th of September 2012 resolved that she be exposed to an additional 6 months of probation under the guidance of an on-board mentor, namely the then acting judicial head of office. However, thereafter further charges were brought against her. The investigation report recommends that the Magistrates Commission charge Mrs. Malahlela with misconduct. A charge sheet comprising of 29 counts of alleged misconduct was served on her on the 5th of March 2014. On the 8th of June 2014, Ms. Malahlela filed a notice of motion at the North Gauteng High Court for a court to order inter alia to declare the Commission's decision to charge her with misconduct to be wrongful and unlawful. The application was opposed by the Magistrates Commission. At its meeting held on the 31st October 2014, the Commission considered Mrs. Malahlela's attorney's request not to proceed with a disciplinary hearing pending the outcome of the High Court review application, since the relief sought inter alia is to set aside the decision of the Magistrates Commission to charge Mrs. Malahlela with misconduct. The Commission resolved to stand by its earlier decision that the misconduct hearing must proceed. Having regard to the fact that it is evident that Mrs. Malahlela is deliberately delaying the continuation of the disciplinary hearing process against her and the serious nature of the misconduct charges preferred against her, the Commission at its meeting held on the 21st November 2017 determined to withhold Mrs. Malahlela's remuneration in terms of Section 13 sub 4A sub A of the Act pending the conclusion of the disciplinary inquiry against her with immediate effect. The Select Committee on Security and Justice, having considered the Minister's report on the Magistrates Commission's determination to withhold the remuneration of Magistrate Mrs. R.M. Malahlela, an aspirant additional magistrate at Dalmas, Mpumalanga, tabled by the Minister for Justice and Correctional Services in terms of Section 13, sub 4A, sub B of the Magistrates Act. The Select Committee recommends that the National Council of Provinces confirm the determination of the Magistrates Commission. I therefore table the report on behalf of the Select Committee to the House for consideration, Chair.
Thank you very much. That concludes the debate. And I shall now put the question, and the question is that the report be agreed to. But in accordance with Rule 71, I shall first ascertain as to whether if there's any province that wishes to make a declaration of vote. Is there any? In the absence of any, we shall then proceed with the voting in an alphabetical order. Eastern Cape.
Eastern Cape support, Chair.
Free State.
Free State support, Chair.
Gauteng.
Gauteng supports, Chair.
KwaZulu-Natal.
KwaZulu-Natal agrees.
Limpopo.
Limpopo redume.
Mpumalanga.
Mpumalanga supports.
Northern Cape.
Northern Cape agrees.
Northwest.
We support, Chair.
Western Cape.
Western Cape support, Chair.
Western Cape, report or support? Yes. Support. Oh, okay. All 9 provinces voted in favor. I therefore declared the report as agreed to in terms of Section 65 of the Constitution. The Secretary will read the 7th order.
Consideration of report of Select Committee on Security and Justice, withholding of remuneration of Magistrate Mr. M.J. Homo, an additional magistrate in Randburg in terms of Section 13, 4A, sub 4A, sub B of the Magistrates Act 1993.
Honorable Mthethwa.
Thank you, Chairperson. Report on the Select Committee on Security and Justice on the withholding of remuneration of Magistrate Mr. M.J. Homo, Additional Magistrate, Randburg, in terms of Section 13(4)(a)(b) of the Magistrate Act 1993, Act number 90 of 1993, reported by the committee on the 23rd May 2018 and published in an announcement tabling and report ATC on the 23rd May 2018. The Select Committee on Security and Justice, having considered the Magistrate Commission's report dated 21st November 2017 as tabled by the Minister for Justice and Correctional Services on their determination to withhold the remuneration of Magistrate Mr. M.J. Homo, an additional magistrate at Randburg, tabled by the Minister for Justice and Correctional Services in terms of Section 13(4)(a)(b) of the Magistrate Act 1993, Act number 90 of 1993, reports as follows. Criminal proceedings and reasons for long delay in finalizing the matter. Mr. Homo was an additional magistrate at Randburg and was appointed to lower court bench in July 2000. He was arrested on the 5th December 2013 and appeared in Randburg Regional Court the following day on a charge of corruption. It is alleged that he demanded and received 150,000 in exchange for positively influencing the outcome of an appeal for extradition brought by the complainant in the particular matter. The complainant had to face charges of corruption in another country amounting to 20 million rand. The money was recovered in Mr. Homo's briefcase, in his office, and in his presence. The regional court convicted Mr. Homo on 2 counts of corruption on the 23rd October 2017 and postponed the matter to 7 and 8 February 2018 for sentencing. Mr. Homo is on provisional suspension since 18 February 2014. The misconduct inquiry against him has been kept in abeyance pending the progress made in the criminal matter. Mr. Homo has now been convicted on 2 counts of corruption. He has been provisionally suspended from office for almost 4 years and with full remuneration. The Commission holds the view that the mere fact that he has been convicted on 2 counts of corruption on its own justifies the withholding of his remuneration pending the finalization of the misconduct inquiry against him. Having regard to the fact that it is evidence that Mr. Homo is deliberately delaying the continuation of the disciplinary process against him and the serious nature of his criminal convictions, the Commission determined to withhold Mr. Homo's remuneration in terms of Section 13(4)(a) of the Act, pending the conclusion of the disciplinary inquiry against him with immediate effect. The Select Committee on Security and Justice, having considered the matter, the Minister's report on the Magistrate Commissions, determines to withhold the remuneration of Magistrate Mr. M.J. Homo, an additional magistrate at Randburg, tabled by the Minister of Justice and Correctional Services in terms of Section 13(4)(a)(b) of the Magistrate Act 1993, Act number 90 of 1993, recommends to the National Council of Provinces to confirm the determinations. I present this report, Chair.
Thank you very much. That concludes the debate. I shall now put the question, and the question is that the report be agreed to. accordance with Rule 71, I shall first ascertain as to whether if there's any province that wishes to make a declaration of vote. Is there any? In the absence of any, we shall then proceed with the voting in an alphabetical order. Eastern Cape,
Eastern Cape support, Chair.
Free State,
Free State support, Chair.
Gauteng,
Gauteng support, Chair.
KwaZulu-Natal,
Support, Chair.
Limpopo,
Limpopo siyavuma.
Mpumalanga,
Malanga, Chris.
Northern Cape,
Northern Cape agrees.
Northwest,
We concur, Chair.
Western Cape.
Western Cape agrees, Chairperson.
All 9 provinces voted in favor. I therefore declare the report as agreed to in terms of Section 65 of the Constitution. The Secretary will read the 8th order.
Consideration of report of Select Committee on Security and Justice, provisional suspension of Magistrate Ms. F.K. Jasone Twala, and acting additional magistrate in George in terms of Section 13 sub 4A sub B of the Magistrates Act 1993.
Honorable Klimby.
Thank you, Chairperson. Chairperson, the Select Committee on Security and Justice, having considered the Magistrates Commission's report dated 21st November 2017, as tabled by the Minister of Justice and Correctional Services on the provisional suspension from the office of Magistrate Ms. F.K. Jasone Twala, and acting additional magistrate at George, pending the outcome of investigation into her fitness to hold office as a magistrate, as required by Section 13(3)B of the Magistrates Act, Act number 90 of 1993, reports as follows, Chairperson. The Magistrate Commission deliberated the matter and reported the following. 1, prima facie evidence exists that she suffers from alcohol dependency, which has a continuous detrimental effect on her daily work performance as a judicial officer. 2, Ms. Jasone Twala is on probation since 2012, and that her probation period has been extended twice by the Commission's appointment committee. There seems to be a progressive deterioration in her conduct, that without anticipating the outcome of the investigation into her fitness to hold the office of magistrate, the available evidence against Ms. Jasone Twala is of such a serious nature that it would justify her removal from office should she be found guilty of the misconduct charges which are preferred against her. The Commission holds the view that it would be in the interest of administration of justice that Ms. Jasone Twala be provisionally suspended from office pending the conclusion of the inquiry into her fitness to hold office. Chairperson, the Select Committee on Security and Justice, having considered the Magistrates Commission's report dated 21st of November 2017, as tabled by the Minister of Justice and Correctional Services on the provisional suspension from office of Ms. F.K. Jasone Twala, an acting additional magistrate at George, pending the outcome of the misconduct hearing into her fitness to hold the office of magistrate, as is required by Section 13(3)B of Magistrates Act, Act number 90 of 1993, recommends the National Council of Provinces confirm Ms. F.K. Jasone Twala's provisional suspension from the office of magistrate. Thank you, Chairperson.
Thank you very much. That concludes the debate. I shall then put the question, and the question is that the report be agreed to. In accordance with Rule 71, I shall first allow provinces an opportunity to make a declaration of vote if they so wish. Is there any province? In the absence of any, we shall then proceed with the voting in an alphabetical order. Eastern Cape.
Eastern Cape support, Chair.
Free State,
Free State support, Chair.
Gauteng,
Gauteng support, Chair.
KwaZulu-Natal,
Natal support, Chair.
Limpopo,
Limpopo Redube.
Mpumalanga,
Mpumalanga, Chris.
Northern Cape,
Northern Cape Radumela Mudula Stilo.
Northwest,
We accept, Chair.
Western Cape.
Western Cape agrees, Chairperson.
All 9 provinces voted in favor. I therefore declare the report as agreed to in terms of Section 65 of the Constitution. Secretary will read the 9th order of the day.
Consideration of report of Select Committee on Security and Justice, withholding of remuneration of Magistrate Ms. F.K. Jason Twala and Acting Additional Magistrate in George in terms of Section 13, Sub 4A, Sub B of the Magistrates Act, 1993.
Honorable Klimbi.
Thank you again, Chairperson. Chairperson, again, the Select Committee on Security and Justice, having considered the Magistrate Commission's report dated 21st of November 2017, as tabled by the Minister of Justice and Correctional Services on their determination to withhold the remuneration of Magistrate Ms. F.K. Jason Twala and Acting Additional Magistrate at George, tabled by the Minister of Justice and Correctional Services in terms of Section 13 4AB of the Magistrates Act, Act number 90 of 1993. Reports again as follows, Chairperson. The Magistrate Commission deliberated the matter and reported the following. Prima facie evidence exists that she suffers from alcohol dependence, which has a continuous detrimental effect on her daily work performance as a judicial officer. She is on probation since 2012, and that her probation period has been extended twice by the Commission's Appointments Committee. Despite her having been admitted for rehabilitation on 3 different occasions during the period of her probation and having been counseled by her colleagues, her conduct has a detrimental effect on the smooth running of the courts, since she would on numerous occasions and without advising her judicial head of office timelessly or not at all, not report for duty. This seems to be a progressive deterioration in her conduct, that without anticipating the outcome of the investigation into her fitness to hold the office of magistrate, the available evidence against Ms. Jason Twala is of such a serious nature that it would justify her removal from the office should she be found guilty on the misconduct charges which are preferred against her. Chairperson, the Commission holds the view that it would be in the interest of the administration of justice that Ms. Josana Twala's remuneration be withheld, while she is previously suspended from office pending the conclusion of the inquiry into her fitness to hold the office. Therefore, the Select Committee on Security and Justice, having considered the Minister's report on the Magistrate Commission's determination to withhold the remuneration of Magistrate Ms. F.K. Jason Twala, an Acting Additional Magistrate at George, tabled by the Minister of Justice and Correctional Services in terms of Section 13 4AB of the Magistrates Act, Act number 9 of 1993, recommends to the National Council of Provinces to confirm the determination. Thank you very much, Chairperson.
Thank you very much. That concludes the debate. I shall now put the question, and the question is that the report be agreed to. In accordance with Rule 71, I shall first allow any province that wishes to make a declaration of vote. Is there any? In the absence of any, we shall then proceed with the voting in an alphabetical order. Eastern Cape.
Eastern Cape support, Chair.
Free State.
Free State, Amoena, Chair.
Gauteng.
Gauteng support, Chair.
KwaZulu-Natal.
KwaZulu-Natal agrees.
Limpopo.
Limpopo supports.
Mpumalanga.
Mpumalanga agrees.
Northern Cape.
Northern Cape agrees.
Northwest.
We agree, Chair.
Western Cape.
Western Cape agrees, Chairperson. Agrees.
All 9 provinces voted in favor. I therefore declare the report as agreed to in terms of Section 65 of the Constitution. The Secretary will read the 10th order.
Consideration of report of Select Committee on Security and Justice, provisional suspension from the Office of Magistrate of Mr. M.D. Hindla, Chief Magistrate Bloemfontein, tabled in terms of Section 13, subsection 3B of the Magistrates Act 1993.
Honorable Mateme.
Chairperson, thank you very much for this opportunity. The Select Committee on Security and Justice, having considered the Magistrate Commission's report dated 29th November 2017, as tabled by the Minister for Justice, Correctional Services, on the provisional suspension from office of Mr. M.D. Hindla, the Chief Magistrate at Bloemfontein, pending the outcome of a misconduct hearing into his fitness to hold the office of magistrate, as is required by Section 13, subsection 3, subsection B of the Magistrates Act, Act number 90 of 1993, reports as follows. Chair, background. The complainant in the matter is a 42-year-old woman from Botshabelo. On 29th July 2016, she lodged a complaint with the minister alleging that she was raped by Mr. Hindla in his flat in Bloemfontein after he made false pretenses to her. Her complaint was submitted to the department, and on the 2nd November 2016, the complaint was referred to the Commission for attention. Secondly, Chair, the Commission holds the view that, 1, the existing evidence against Mr. Hindla is of such a serious nature as to make it inappropriate for him to perform the functions of a magistrate while the allegations are being investigated. 2, Mr. Hindla's conduct tarnishes the good name, dignity, and esteem of the office of magistrate and the administration of justice. 3, without anticipating the outcome of the investigation, Chairperson, into the fitness to hold the office of magistrate, the available evidence against Mr. Hindla is of such a serious nature that it would justify his removal from office should he be found guilty of misconduct charges which are preferred against him. Chairperson, committee recommendations to the NCOP for approval. The committee therefore recommends, after having considered the Magistrate Commission's report dated 29th November 2017, as tabled by the Minister for Justice and Correctional Services on the provisional suspension from office of Mr. M.D. Hindla, the Chief Magistrate Bloemfontein, pending the outcome of a misconduct hearing into his fitness to hold the office of magistrate, as is required by Section 13, subsection 3B of the Magistrate Act, Act number 90 of 1993, recommends that the National Council of Provinces confirms Mr. M.D. Hindla's provisional suspension from the office of magistrate. We table the report. Thank you.
Thank you very much. That concludes the debate. And I shall therefore put the question, and the question is that the report be agreed to. In accordance with Rule 71, I shall first allow provinces an opportunity to make a declaration of vote if they so wish. Is there a province that wishes to? In the absence of any, we shall then proceed with the voting in an alphabetical order. Eastern Cape.
Eastern Cape yavumelana sihlalo.
Free State.
Free State amwena Chair.
Gauteng.
Gauteng concurs, Chair.
KwaZulu-Natal.
KwaZulu-Natal agrees.
Limpopo.
Limpopo siyavuma.
Mpumalanga.
Mpumalanga agrees.
Northern Cape.
Northern Cape agrees.
Northwest,
We agree, Chair.
Western Cape.
Western Cape agrees, Chairperson.
All 9 provinces voted in favor. I therefore declare the report is agreed to in terms of section 65 of the Constitution. The Secretary will then read the 12th order of the day.
Consideration of Plant Improvement Bill, B8D 2015, and report of Select Committee on Land and Mineral Resources thereon.
Honorable Sefako.
Thank you very much, Honorable Chair, honorable members, for the opportunity to table before this House the report of the Select Committee on Land and Mineral Resources. The NCOP referred the Plant Improvement Bill, B8D 2015, to the Select Committee on Land and Mineral Resources on the 17th of November 2016. The bill is one of a number of Section 76 bill referred to the committee during this period. The department briefed the committee on the 1st of August 2017. The delay in commencing the processing of these bills as a result of the committee at that time focusing extensively on the processing of the MPRDA. The committee successfully applied for extension of the 6-week cycles from the NCOP in order to process the bill effectively. The bill, together with the Plant Breeders' Right Bill, was referred to provinces for development of mandate, while public inputs were also sought. From the inputs received, it was clear that the public was concerned about the policy directions of the department. In particular, questions was asked regarding the department's perceived support of policy development with a multinational, large-scale, commercialized approach. It was felt by those that commented on the legislations that the significant number of small scales and traditional farmers would not benefit significantly from the legislation, and that the upliftment of this farming sector was more important than adhering to international agreements that benefit a handful of seed producers. These concerns were debated in the committee and referred to the department for comment. Robust discussions about the objective of both pieces of regulations followed. The department was confident that the proposed amendments to the Plant Improvement Bill would not impact negatively on the development of small-scale farmers and the traditional practice of subsistence farmers. The amendments are required to strengthen the rise of seed producers and plant breeders in South Africa, as well as to enforce our international commitment towards safeguarding plant breed rights. The committee held 2 meetings to deal with deliberations on the negotiating mandate received from provinces on the 21st and the 28th of November 2017. The committee was satisfied that the department could clarify most matters of concern raised in the submissions received from the public, as well as in proposals contained in the negotiating mandates of provinces. The bill was adopted during the final mandate meeting held on the 22nd of May 2018. I move for adoption of this bill.
Thank you very much. That concludes the debate. I shall now put the question, and the question is that the report be agreed to. In accordance with Rule 71, I shall first allow provinces an opportunity to make a declaration of vote if they so wish. Is there any province that wishes to? Free State?
This is the declaration of Free State with regard to planned improvement bill. As the economic freedom fighters, we categorically reject this planned improvement bill before this House. The bill is another
Honorable
attempt.
Honorable Chabangu, can you take a seat? Can I take a point of order?
Point of order, Honorable Chairperson. I'm the leader of delegation. We don't have a declaration. I didn't even allow Honorable Shabangu to make a declaration on behalf of the province. Thank you, Honorable Chair.
Honorable Shabangu. Can you take your seat, Honorable Mukwe? Honorable Shabangu, a matter has been brought to my attention that the province does not have a declaration. And that matter is being brought then to my attention by the leader of the delegation.
Mandate. I'm not.
She says the province does not have a declaration.
We have never agreed with her that she has never allowed me to do so.
Honorable Shabangu, let's not reduce this thing now to another thing. This is a provincial declaration in the province. The leader says that the province does not have a declaration. Yes, can I have
on a point of order, Chair. You know, Chair, when we are in the House, I expect those people that are seated in that table not to be partisan. We have seen advocate, I don't know his surname, pushing Honorable Moshodi to stand up. Honorable, English is not my language, I don't care how I pronounce it. Honorable Makosini was already on his 3rd sentence of the declaration before Honorable Moshodi could stop him. So I'm again, Chair. I don't care whether you are taking the declaration or you don't take a declaration, it's fine. I'm just highlighting to you again that if you take the decision now, you are going to take a 6th decision today that is wrong. It's fine, you can take it. He will stop, he will not do the declaration if you say so. But it will be the 6th illegal decision that you have taken today only.
Well, maybe it should have been the 10th or the 100th decision. But the fact of the matter is that The fact of the matter, Honorable Mukweli, I want to address a very substantive issue that you raised. These other side issues, for me, are not so much important. Whether it's the 100th or the 2000th time or what, it's immaterial. What is important for me here is that the leader of the delegation rose to say that the province does not have a declaration. I listened to whether what happened here or whatsoever, I'm looking at you. And my attention was drawn. Honorable Mukwele, I've made a ruling on the matter. Are you on this subject matter? Are you on this subject matter? Oh, sorry.
No, Honorable Koni is on a point.
My apologies. My apologies. Are you on this subject matter?
No. Chair, I saw Advocate Mbebe with my own two eyes.
Honorable Mukwele, you
directing honorable member from the Free State
Honorable Koni,
like this.
Honorable Koni,
but Mama
Honorable
Dlamini,
Koni,
she wants to best in the
Honorable
laugh now.
Koni,
Mama
I've
Dlamini.
made a ruling on the matter.
She
Can
wants
you
to
please take
laugh.
your seat? Can you take your seat, please? Can you take your seat? Honorable member, can you take your seat? Can you take your seat, please? Honorable Shabangu, on what matter are you rising? It's on the same subject matter. Now, if it is on the same subject matter, I'm not going to allow it because I've made a ruling on the matter. I've made a ruling on the matter.
But Chair is unfair.
Honorable member, I've made a ruling on the matter. Honorable member, I've made a ruling on the matter, and it is as simple as if you had seen it, I had not seen it. There are processes that can be followed by any member
It's very much
to lodge a
unfair.
complaint. Okay, thank you very much. Western Cape? Western Cape?
Thank you, Honorable Deputy Chair. This bill penalizes farmer-to-farmer exchange of seeds and plant materials and restricts space for exchange and sharing in the future. It goes against long-held practices of sharing plants and seeds between farmers, especially smaller and less commercial producers. Further, it places a restriction on diversity ranges and innovation by smallholders and small enterprises. The processes followed during the provincial mandates were flawed and minimum amendments were made by the Select Committee on Land and Mineral Resources. In fact, there was chaos and confusion during the voting process. Chairperson, even the ANC Western Cape from the legislator there also opposed this bill. Therefore, Chairperson, the Western Cape province cannot support the bill. I thank you.
Thank you very much. I don't see any other declaration. We shall therefore proceed with the voting in an alphabetical order. Can we please proceed, honorable members? You are doing exactly what you are cautioning the House not to do. Exactly. But in any case, it's fine because it suits you. It's all right. Eastern Cape?
Eastern Cape support, Chair.
Just take your seat, Honorable Member. In terms of the records of this parliament, Kerasiriti Johannes Tau.
Honorable Cape is doing.
Can we proceed with the voting on Eastern Cape?
Eastern Cape support, Chair.
Free State?
Free State, yeah, I'm on a chairperson.
Gauteng?
Gauteng supports the bill, Chair.
KwaZulu Natal?
KwaZulu Natal supports.
Limpopo?
Limpopo re a dumela.
Mpumalanga?
Mpumalanga agrees, Chair.
Northern Cape?
Northern Cape agrees.
Northern Cape insofar as the honorable members order. Order. Why are you on your feet, honorable member?
No, I want to vote, Chair.
No, I'm still with the Northern Cape.
Oh, you're addressing me, Chair. Okay.
Yeah. Insofar as our records shows, the the Northern Cape legislature did not send a full voting. So there's no Honorable Mokweli. Honorable Mokweli, I'm not addressing you. I'm addressing Honorable Stock. That the province did not submit a voting mandate.
Okay. Thank you.
Okay.
I so
Northwest.
I so move, Honorable Chair.
Northwest.
Agreed,
Northwest.
Chair.
Northwest.
Does not agree,
Northwest,
Chairperson.
the record show, no. I'm still with Northwest.
We are still sorting.
Like exactly, that is why I'm saying they're doing exactly the same thing that they are cautioning the House about. They are the loudest. Members cannot even hear each other. Northwest, we are sitting with a similar problem where the legislature did not submit a voting mandate.
Chair, according to my record, we did not submit the final mandate, but the voting mandate was sent.
Final mandate is the one that. Western Cape.
Western Cape does not agree, Chairperson.
6 provinces voted in favor and 2 provinces did not have a final mandate. Can I conclude what I'm doing, ma'am? Thanks. 6, yes, I'll come back to you. 6 provinces voted in favor and 2 with no final mandate for the legislation. And 1 province voted against. So the majority of provinces voted in favor of the bill and therefore declared the bill as agreed to in terms of Section 65 of the Constitution. Honorable Mokweli, you wanted to address me.
No, I wanted to check, Chair, Honorable Stock, was he aware of the position of the province? Because by the look of things, he was voting. So we want just to check. And then you alerted him that there's no mandate from the province. Thank you.
Honorable members, that's not a point of order, and therefore I would not even subject myself to debate on that matter. Honorable, the Secretary will read the 13th order.
Consideration of Plant Breeders' Rights Bill, B11D 2015, and report of Select Committee on Land and Mineral Resources thereon.
Honorable Sefako.
Thank you, Honorable Chair. These 2 bills were submitted simultaneously and deliberated to on the same day. Also with the extensions sought from the NCOP. Can attest that the committee held 2 meetings to deal with deliberations on the negotiating mandate received from provinces on the 21st and 28th November 2017. The committee was satisfied that the department could clarify most matters of concern raised in the submissions received from the public, as well as in proposals contained in the negotiating mandates of provinces. The bill was adopted during the final mandate meeting held on the 22nd of May 2018. I then move for adoption of this bill as well. Thank you, Chair.
Question, and the question is that the report be agreed to. However, in accordance with Rule 71, I shall first allow provinces an opportunity to make a declaration of vote if they so wish. Is there a province that wishes to? Western Cape. Western Cape.
Thank you, Deputy Chair. This bill favors the extension of control and power of multinational corporations over plant breeding and agriculture at the expense of farmers, especially smallholder farmers. It limits the expansion of diversity of seed systems and criminalizes long-standing practices of seed exchange, which is totally inappropriate in relation to intellectual property rights and the protection thereof. Further, the legislative process followed by the Select Committee on Land and Mineral Resources was fundamentally flawed and leaves the bill open to legal challenges. Once again, Chairperson, even the ANC in the Western Cape opposed this bill. And therefore, once again, the Western Cape province cannot support the bill. I thank you, Deputy Chair.
Thank you very much. I don't see any other province. We shall now proceed with the voting, and we'll do that in an alphabetical order. Eastern Cape.
Eastern Cape support, Chair.
Free State.
Free State support.
Gauteng.
Gauteng support, Chair.
KwaZulu-Natal.
Natal support, Chair.
Limpopo. Mpumalanga.
Mpumalanga, Chris.
Northern Cape.
Northern Cape siyavuma.
Same situation again, Northern Cape. Don't have, Honorable members, honorable members, honorable member Koni, honorable member Mukwe, can you please allow me an opportunity? Side. We don't have a final voting mandate from the Northern Cape. Northwest. Honorable members, honorable members, honorable members, I'm bringing it to the attention of the leader of the delegation that there is no final voting mandate from the province.
He doesn't know. The leader of delegation.
Northwest. Northwest.
Agreed, Chair.
No mandate.
No mandate. No.
Western Cape. Western Cape.
Opposed, Chairperson.
Six provinces voted in favor. 2 provinces did not submit their final voting mandates, and 1 province voted against. So therefore, the majority of provinces voted in favor. I therefore declare the report as agreed to in terms of Section 65 of the Constitution. Honorable members, honorable members, may I bring the following to your attention, that on the 30th of May 2018, I committed to the House that I would come with a ruling on a point of order raised by Honorable Isaac against Honorable Wana during a debate on vote number 20 and number 23. The Honorable member rose on a point of order and stated that Honorable Wana was misleading the country by stating that the DA under the Nationalist Party, Honorable Kaula, the DA under the Nationalist Party killed people and individuals at Flag Plus. I undertook to consult Hansard transcript and revert with a ruling, as I did not hear what the Honorable member was alleging. The question before the House is whether or not the Honorable Wana had made such statements as alleged by Honorable Isaac, and if so, did he deliberately mislead the House? That is Honorable Isaac. Having consulted the answer transcript, Honorable Wana is recorded to have said the following. Honorable Wana is recorded to have said said the following, and I quote, "Shame on DA for selling their manifest after killing innocent people during the time of the National Party programs." Honorable members, the honorable member did not say sounded similar and could have been interpreted as the DA killed people. Honorable members who have previously ruled in this House, all members of Parliament have freedom of speech, which is expressly constitutionalized in Section 71 and further embedded on Council Rule 30. We have further ruled that references to political parties is not unparliamentary. The courts have favored the use of robust and emotive language during parliamentary debates as held in the Constitutional Court judgment of Democratic Alliance versus African National Congress, and I quote, "Political life in democratic South Africa has seldom been polite, orderly, and restrained. It has always been loud, rowdy, and fractious. That is not a bad thing within the boundaries of the Constitution says. It is good for democracy, good for social life, and good for individuals to permit as much open and vigorous discussion of public affairs as possible," unquote. It is evident from the judgment laid by the courts that members' freedom of speech is tantamount to the promotion of an environment that is representative and of open and democratic society. I therefore rule that the point of order as raised by the Honorable Isaac is not sustained. Hence, I see it fit not to proceed into the further legal analysis of whether or not Honorable Wana's statement had misled the House. I would like to take this opportunity to caution members to take heed of previous rulings delivered in this House and further to encourage members to advocate for an environment that promotes robust debates rather than to rise on spurious points of orders. That's my ruling. On the ruling of on a point of order raised by Honorable Mtetwa, against Honorable Faber on the 17th of May 2018 during the policy debate budget vote 26 on energy. The honorable member rose on a point of order and alleged that Honorable Faber was misleading the public where, and I quote, when he said, I quote, "Where did he see Zuma looting?" Unquote. I undertook to consult Hansard transcript and revert with the ruling, as I did not hear what the honorable member was alleging. Having consulted Hansard transcript, Honorable Faber is recorded to have said the following, and I quote, "We would condemn an actual imprisonment. We will condemn an actual imprisoned President Zuma, the Guptas, Mr. Brian Molefe, for looting from government through inflating the controversial 1,064 locomotive tender to which the Gupta-linked businesses scored from 38 billion rands to 54.5 billion rands with these inflictive," unquote. This is answered. That is what he said. It's not what I read. It's not what I say. So the words there. The question is therefore whether the statement made by Honorable Faber can be deemed as parliamentary. Section 71 once more of the Constitution read with the powers and privileges and immunities of Parliament and Provincial Legislatures Act, and Council Rule 30 affords members of the Council the right to freedom of speech. This fundamental right is crucial as it recognizes that members should be free to speak their minds in debates without fear or favor. It was held in the Supreme Court of Appeal case of Chairperson of the National Council of Provinces versus Malema, Honorable Malema, that the Constitution does not allow the presiding officer to limit a member's freedom of speech unless authorized by the rules of parliament or a standing order. In our previous rulings, our presiding officers, as presiding officers, we have discouraged rather than make a ruling to members from referring to persons who are not members of parliament and who are unable to reply in their own defense because they are not members of parliament. Both in the Westminster system, in our own South African system, members of parliament have a responsibility to protect the public, not only from outright slander, but also from any slur directly or indirectly implied upon them as members of the public. Therefore, the ruling is as follows. While making an allegation against a non-member of parliament, it is unparliamentary. While making an allegation against a non-member of parliament is not unparliamentary. However, I appeal once more, and not only to me, on behalf of all presiding officers, that to members to avoid as much as possible during the course of debate, mentioning people from outside of parliament who are, by any chance, unable to reply in their own defense, as they are not members of parliament. That is the conclusion of the ruling. Members, that concludes the business of the day, and the House is adjourned.